Welcome to the Federalist Radio Hour. I'm Emily Jashinsky, culture editor here at the Federalist. As always, you can email the show at radio@thefederalist.com. I'm coming to you today from Washington, D.C., where our guest is Kristen Waggoner, the general counsel of Alliance Defending Freedom. ADF has had 11 cases before the Supreme Court in the past 9 years. Kristen Waggoner herself has argued some of those, including the Masterpiece Cake Shop case. Kristen, thank you so much for joining us.
Thanks for having me.
Well, I want to start off by asking you, as somebody who's argued before the Supreme Court, and specifically as somebody who's argued before Ruth Bader Ginsburg, what you think her judicial legacy will be going forward, and maybe what you think it should be.
Well, I think I'll start with her personal legacy. I disagreed with nearly all of, I would say, her judicial philosophy in terms of the decisions that she issued. Many of those decisions I disagreed with. But I do want to start with just a personal admiration that I did have for her, and that I think all women should have, in particular, all people, but all women in particular, because it really was true what Judge Coney Barrett said the other day, that she shattered glass ceilings. And I think that's important. The tenacity with which she approached her profession and really her formidable legal mind is something that should be respected. I don't necessarily respect or admire what she did with that, but there's no question that in arguing before her, you took her seriously. You knew she would treat you with civility in the courtroom and would ask difficult questions, but often fair.
Yeah, so I imagine your memory of arguing before Ruth Bader Ginsburg is that she was somebody who did ask really tough questions and probably often on the other side of your argument, but remained civil. Now, would you say, as the Supreme Court has taken on, has sort of crept into what a lot of people would say is the role of the legislative branch, would you say that Ruth Bader Ginsburg was somebody who was at the forefront of that shift in the judiciary?
I'm not sure that she was at the forefront of the shift into that. I agree with your assessment that they engage in policy making much more than is probably healthy for our democracy. And I have strong concerns about that. But I think that even started perhaps long before she took the bench and continued once she was on it. I do think that she perpetuated that in many ways, particularly in her sense that abortion, for example, was a necessary element to women's equality. And that, I think, was wrong. In addition to, in Masterpiece, she was on the wrong side of that, too. It was a decision that was 7-2. So we definitely drew in a broad diversity of opinions in that, but still she and Justice Sotomayor were on the wrong side. So there was definitely a strong ideological component to her decisions.
Right. And I wonder, going forward, to the woman that President Trump has nominated to fill that seat, that would be Coney Barrett, what your assessment is of her ability to take that seat, of her, what we could predict from her as somebody who sits on the bench.
Well, Judge Barrett has taken a very different position in her writings, and if you just look at what she said and what she's written, and even her rulings since she's taken the bench in the Fourth Circuit, very different from Justice Ginsburg in pretty much every respect, I would say. One of the things that I get a kick out of is people suggest, we shouldn't have, Judge Barrett might be too ideological or this or that, and yet Justice Ginsburg was appointed to the bench after being the general counsel at the ACLU. So I don't know how that double standard works, but it's unfortunate. With Judge Barrett, though, I would say, everything she's written suggests that she is an originalist, and that means something. It should give us all hope.
You just briefly mentioned the ACLU, which is amusing to me because the ACLU, yes, used to be a little bit less ideological than it is right now. I wonder quickly what your opinion on what it is that has happened to the ACLU in recent years. They've gone from really being able to get themselves to defend, to muster these defenses of people on, who are transgressing perhaps our rules of decorum on both sides of the aisle. And now they're just on completely a far left group, basically.
I completely agree with you. I remember being in law school. I was in law school in the 90s, and just, thinking that I would go into the practice of law and we would have these civil debates and disagree on things, and yet still be able, again, to respect one another, to play fair, and to let the best ideas win. And we're not in that era anymore. And the ACLU was a part of that. I mean, they stood for the rights of free speech. When I clerked at the Washington Supreme Court, even, one of the judge that I clerked for, he was brought up on charges potentially because he spoke at a rally. And of course, the ideologues in Washington state wanted to essentially get this conservative judge off the bench. And the ACLU represented my judge in that action, and that was like 1997. That would never happen today. They've essentially established a hierarchy and bought into the progressive left agenda. So that means that some people get rights and others don't. It's completely based on ideological purity at this point.
Well, and the reason I wanted to go, to pursue that tangent a little bit is because I think it speaks to a larger issue in our culture, and it's one that you guys confront a lot in your cases. And I'm sure it's something that you notice more and more is becoming front and center, which is that the boundaries of acceptable speech, acceptable beliefs, and acceptable conduct are narrowing. And a lot of these cases, I imagine, land in your all's lap because of that, because we have these new cultural standards about what it's okay to say and do and believe. And it seems like that, somebody hit the fast forward button and we've accelerated so rapidly in such a short amount of time.
You're absolutely right. Our calls into our intake department have skyrocketed in the last couple of years. It's hard to even keep up with, especially the number of individuals that are suggesting that their free speech rights or their right to the free exercise of religion, the right to live consistently with their faith, is under attack. And as you bring this up, just yesterday, one of our attorneys argued in a Florida federal court on behalf of Jack Denton, who Jack was a student at Florida State University. He was elected to the the school senate as president, made a comment in a private Catholic chat group that he supported the notion of racial equality, but disagreed with blacklivesmatter.com, their intention to destroy the nuclear family. And that got him expelled from the state senate, which is overt religious discrimination. And so there was a hearing on that just yesterday. But those are the kinds of instances that are happening on public campuses and all over America. And it's why the Supreme Court at this point and who serves on it next is also important. We need someone that's committed to protecting the constitutional rights of all Americans, no matter what side of the aisle you're on.
Yeah, and what's interesting to me is that we look at the Supreme Court, and by the way, I say this is interesting to me because I don't work on these issues every day, but we look at the Supreme Court as the bulwark. This is what's supposed to be the line of defense for our liberties, and it does seem like the Masterpiece case is such a good example of that, this is supposed to be where, and the courts failed. I mean, the courts failed along the way in that case, and I do wonder if you think some of these attitudes are really creeping into the courts in a way that is alarming.
I do. I mean, we have seen in many ways, I think of the Supreme Court, like you said, as that last line of defense. It's to ensure that the different branches of government and that the state governments are obeying, following the Constitution. And it's a shame that so many of these issues are getting there. I mean, you mentioned when you opened that we've had 11 Supreme Court victories in the last 9 years. In a way, that's a good thing that we've won those cases, but in another way, that's very, very bad. It's a shame that those types of issues are even reaching the court. And I think it's, again, important why when we think about what's next, I mean, we probably both watched that debate last night, and you think about where are we going from here? it's a bigger problem than just what's at the Supreme Court, but that has to be part of the solution, is that we protect the rights of all people and we stop this cancel culture movement.
Right. And so why is the judicial philosophy of somebody like Amy Coney Barrett, who's very much in the tradition of Scalia, why is it important to have judges like that on the bench as opposed to somebody like Ruth Bader Ginsburg?
Well, because traditionally, I would say that the progressive left uses the courts in order to shut down the rights of those with whom they disagree. And when they do that, those courts are engaging in policy making. They're not sticking with what the Constitution has told them their job is, which is to apply the law, not to make the law. It's the people's right to change the laws. And that is done in our legislative system. When the courts assume that responsibility by doing it in a court decision, they deprive that right from the people. And it results in bad decision making because there's just not enough reasoned analysis. You're not hearing different views. So an originalist is fundamentally committed at their core to apply the law as it is written, to read the words and take them in the historical context and not change the law.
Right. And so you think that people should be fairly confident that Amy Coney Barrett would fulfill that philosophy were she to be confirmed. She's somebody who she hasn't been in her position for years and years and years, but you feel fairly confident that she would be able to do that.
I do believe that she's an originalist. Now, we've certainly seen from this last term, as well as from examples of other Republican appointees, we can never guarantee what a judge will do, how they will rule, and if their views will change as they sit on the bench. But I think as in the practice of politics, in the practice of the judiciary, and in the practice of everyday life, we look at what people say and what they do. And so far, what Amy Coney Barrett has said and what she has done lines up with a judge who would not engage in policymaking, but would apply the law as it's written.
Already, we've seen some threats for the left that if Amy Coney Barrett is confirmed, if Republicans go ahead and go through with this confirmation, they will try to pack the court. Why is that such a dangerous idea?
Oh, I know it is. I was. My kids were even saying something last night when Vice President Biden refused to answer that question because it's terrifying in many respects. I mean, if we think of the Supreme Court as kind of the last bastion in this season to protect the rights of freedom, to have any the Republicans or the Democrats make that into a partisan weapon it's scary in terms of the future of our constitutional freedoms. And I'm hopeful that they won't do that and that they'll learn from, the last time this happened was with Franklin Delano Roosevelt, and he backed off as well. Our courts shouldn't be partisan weapons.
Right. I was going to ask, in fact, about the history and how that should perhaps be a guide for the left on this issue, but you brought it up anyway. It seems as though that the left sees the court very differently than the right does, increasingly sees the court very differently than the right does. Is there, what would you say would be the best argument to somebody on the left who perhaps has that view of the court as to why it should be protected protected to remain as an institution as it has traditionally served?
Well, I would first say that what's good for the goose is good for the gander. And we, more and more we're seeing decorum and our commitment in our society to basic rules and standards that we've abided by go by the wayside. So Democrats can be assured that if they're going to pack the court, then the Republicans, when they get back in power, will likely do the same thing. And this will keep going and going until the court's decisions are meaningless. I think a better route is to have the legislatures at the state level and Congress do their job. And that's why I like the idea of originalists on the court, because it forces the executive and legislative branches to do their job. If they refuse to engage in lawmaking and simply apply the law, then that puts the people back in control. And I think that's a good thing overall.
Now, I want to ask a question about the Equality Act. I actually want to talk about the Equality Act a little bit here because it's one of those issues that it's one of those bills that has a great name. They really gave it a good name, and they're good at that here in Washington. But it's not it's not as harmless or innocuous as it sounds, and it's actually been promoted by a lot of celebrities. I mean, just about every mainstream Democrat politician says that they support the Equality Act. It would have sweeping and radical consequences for our society, and I was wondering if you would speak a little bit to what we could expect to see in this country if the Equality Act were passed.
Oh my, I can't think of a law in my lifetime, and perhaps even longer period than that, that is more destructive and corrosive to religious liberty and to freedom of speech and to our freedoms in general. It would literally shred them. So what the Equality Act does is it elevates sexual orientation and gender identity as a protected class in the law, and it provides absolutely no ability for religious organizations or people of faith to be able to speak or live consistent with their views if they share a different view on human sexuality or on gender identity. And the way that plays out, for example, is it completely obliterates the differences between men and women. And that should be offensive to feminists and to progressive leftists. It should be if they were consistent. And fortunately, they're not consistent. But if you think about our kids, our daughters being in dorm rooms with guys, that's what it allows. If you think about sports and our daughters having to compete against men in sports as well, that's what it allows. It allows shelters, women's shelters. We represent some of them that have actually been taken essentially to court because they declined to allow violent individuals who were dressed as women into the shelter. And it was not only scaring the women because they knew of this particular individual, but they're sleeping 3 feet away from men. So the Equality Act has all of these implications to it, and I haven't even gotten to the religious implications that will harm our families, our communities, and our institutions.
And it's not just even a matter of allowing. In some cases, it would be mandated, right? So, for instance, the case that you're working on in Anchorage, the women's shelter, this is a matter of them being forced to admit a biological male into a women's shelter and sleep beside victims of domestic abuse, essentially, and they're powerless to stop it.
You're absolutely right. All of those instances that I raised were literal calls that we've had of colleges and universities imposing this. We have cases right now where professors have been compelled to have to say things in the classroom and to address individuals using pronouns that violate their convictions. We have sports cases right now involving athletes who are losing places on the podium and scholarships because young men are being able to compete with them. It just goes on. And there's a case at the Supreme Court this term called Fulton involving religious adoption agencies. And we also have a case that we recently won at the Second Circuit involving that. And that too is in play in terms of whether religious organizations will be able to continue to place children in homes with moms and dads, and whether they can even make the distinction between men and women.
Yeah, and this reminds me a little bit of the Equal Rights Amendment fight, in the 80s, where there was a lot of 70s and 80s, where there was a lot of conversation about, the right-wing scaremongering, that all of these predictions about what would come to pass should the ERA be ratified, they're just scaremongering. They're not rooted in anything real. They're just kind of the worst case scenario, isolated incidents that would happen. But you guys are working with people who are already seeing the consequences of, blurring the legal distinction between men and women.
You're absolutely right. And if you want to talk about the left's ability to name bills well, the ERA is another fine example because that bill too, you said it's in the 70s, and it absolutely is. In fact, the CEO of ADF litigated it in the 70s and I think it was the early 80s. And now we're doing it again. Not too long ago when Virginia passed the ERA, I was there in Virginia and spoke at a conference there talking about the destructive nature of that again, that eliminates the distinction between men and women. We are equal, but we are not interchangeable. and it hurts women and girls when we suggest otherwise. And I would say under the Equality Act as well, if you think about creative professionals and Christians who believe marriage is between a man and a woman and who serve everyone, but don't want to engage in creative projects that cause them to express messages that violate their faith. The Equality Act would take away their right too and force them to engage in projects that would violate who they are and their core convictions.
Right, and this gets back to Masterpiece, but if you could speak a little bit about what the distinction should be legally between, if somebody serves a customer who might be LGBT and then somebody who actually has to create a creative project for a wedding and pronouns are similar to this. It's one thing to teach a student who identifies with the LGBT community, but then actually being compelled to refer to that student by pronouns that do not accurately identify their biological sex is a totally different matter.
It is. It's about compelled speech, and never have we compelled people to say things or to create things that would violate their core convictions when it comes to ideological convictions that they have. So we're in uncharted territory if that were to happen under the Equality Act. We've seen states try it, and that's why right now, for example, Baronell Stutzman's petition for Arlene's Flowers is pending at the U.S. Supreme Court. It's been sitting there for a year. Her previous decision against her was wiped out by the Supreme Court in Masterpiece. She went back down to the Washington Supreme Court, which is very leftist court, and they cut and pasted the original decision, thumbed their nose at the U.S. Supreme Court, and now it's back. And it's a critical issue. I mean, if we think about this idea of tolerance being a two-way street, I think it's conservatives that actually embrace tolerance, but the progressive left no longer does. So we don't want to force lesbian graphic designers to have to express messages that violate their convictions, or an African American to engage in a project for the Aryan Church. The rule needs to apply both ways.
It is, as you said, the notion that we're entering uncharted territory it goes back to our conversation earlier when we were talking about how there's now this narrow boundary of what's acceptable and what isn't. And that's where these cases, I have to imagine you expect them to proliferate in the years to come. It seems like the trend is that these cases are becoming more and more every year, and not the opposite, that the argument is being won, and I mean the broader sort of argument in the public arena is being won. It seems as though people are really starting to internalize this idea that disagreeing with somebody can be tantamount to hating them, or really in some cases committing violence against them. They literally go that far.
Yes, they do. And we have a whole team of attorneys that work on college campuses and are working with students who face that kind of dogma every day. And if they speak out against it, many times their speech is restricted, and they're even subjected to discipline by the university. And it's important that we hold the line on that for many different reasons. In terms of the proliferation of it, though, I agree with you. We have seen a proliferation. It's important that we win that issue, not just for ourselves, but those with whom we disagree. It's important in this season that the Supreme Court resolve that issue. Let me tell you on Jack Phillips, for example. He won his case at the Supreme Court. The Supreme Court said 7-2, you were hostile against him. You can't treat people of faith like that. Literally 3 weeks later, Colorado came after him again. We then essentially won that case by uncovering more hostile statements they made. And now Jack is in litigation a third time. He's still litigating this issue because a transgender attorney sued him for not designing a custom cake that would celebrate a gender transition. And the cake was blue on the outside and pink on the inside. So we need the court to affirm the freedom of all Americans to be able to speak and live consistent with their faith. And until that happens, I think we'll continue to see these kinds of lawsuits.
And people like Jack Phillips, they must be getting targeted deliberately, like baited into these lawsuits, essentially, right?
It's infuriating on my end. I look at, for example, this case with Jack. It's Autumn Scardina is the attorney. And Scardina began targeting Jack when his case was first going through the Colorado system, sending emails, calling Jack, a bigot, a hypocrite, all these things, then started targeting him with test cases, asking if he would design a cake with Satan on it, celebrating Satan's birthday while he was smoking marijuana. And again, like this gender identity cake, it's a complete setup. They are about ruining people, and the end justifies the means.
And one thing that you've discussed a couple of times in our conversation is that, when the shoe is on the other foot, the left is, they won't like it so much. And you just mentioned the example of, a Black graphic designer being compelled to do work for a white supremacist organization or something to that effect. One of the interesting things to me about the Equality Act is it's very much a fourth wave feminist project, I should say, because it kind of erases some of the victories that women won when they were fighting for women's rights in the second half of the last century, in terms of like separate bathrooms. That's something women actually had to fight for. Isn't it interesting how some of these feminist projects actually are erasing the work of their, as they would probably say, feminist foremothers?
I would love to hear your take on that. You're more into culture and a whole lot younger than me, but I literally have been racking my brain as to why are some feminist groups so invested in this? And the only thing that I can come up with is they're invested in essentially the deconstruction of the family, and that having autonomy is the critical principle. And if you don't have ideological purity, it doesn't matter whether you're a woman. It's all about the end game. But it makes no sense to me. But I am thankful for those who are truly radical feminists have actually lined up with us to defend the rights of athletes and others who are suffering because of this gender identity agenda.
And the Equality Act, to jump back to that, because I think it's it's an example of a lot of what's happening on the left and more broadly in our culture. The Equality Act basically, as you mentioned earlier, blurs the legal distinction between men and women. We kind of saw the Obama administration try to do that with a directive in 2011. It was a Dear Colleague letter that legally would have had the ramifications of something as sweeping as the Equality Act, because it would change the way that courts are told to interpret men and women and gender identity. Does it really come down to that label of gender identity, that the left wants to substitute that in documents like Title IX, like whatever these laws? It comes down to them wanting to use that phrase gender identity instead of biological sex, or with biological sex. Is that a way to put it?
Yes, I think that is the tack that they're taking, and it is to obliterate those distinctions, that there is no difference between men and women. There shouldn't be any differences between men and women, and that harms primarily women and girls. And we're seeing that play out on a daily basis, literally, in terms of the kind of calls we're getting from families. We have a case right now that we're co-counsel on out of Wisconsin, and there's a school district there where they literally have put a policy in place that tells teachers to hide from parents if their child is struggling with gender dysphoria, and to fool those parents, to speak lies to those parents. I mean, it's shocking where we're headed. And it doesn't just, those that might say, oh, I don't care about this or that, or I'm not religious. It's so far beyond that. It goes to parental rights. It goes to our free speech rights. And it essentially makes enemies of the law anyone who disagrees with the fact that we are, I would say, anyone who disagrees with the notion that we decide who we are and that there's no objective reality.
A question that just occurred to me that I'm curious to hear your answer on is, especially since you guys do so much work with students and college campuses, it seemed like what happened this last summer is that people finally awoken. They were awakened to the reality that what has been happening on college campuses for a while has started to hit that point of critical mass, and they've exported all of these graduates who've been taught to have this narrow boundary of acceptable speech and have been taught things about sex and gender identity that would be radical by any recent standard, except for like the past 5 years. They've been exported into the working world, and rather than being shaped by the working world, they are shaping the working world. And I'm curious to hear, as somebody who's been looking at these cases for years and encountering some of these cases for years, you really had a front row seat to what was happening. And were you, when in the summer, when things really accelerated and people were just kind of marveling at what had happened and reeling, were you kind of like, yeah, this has been going on for years? And were you almost frustrated by the fact that people just hadn't been watching closely enough?
Very much so. I mean, I was in private practice for 16 years at a firm in Seattle before I came to ADF. So this is sort of a second wave for me. And what really prompted me to make that move was Barronell's case that we talked about earlier. And so right when I came, I did a lot of public speaking on Barronell's case. I argued her case at the Washington Supreme Court as well. And also I was litigating Jack's case. And we would go into these areas, even with conservatives or libertarians, and they would essentially say, oh, that's just one case. Like, they would just suggest, you're a right-wing, radical, crazy, you don't know what you're talking about. This is just a one-off. It's liberal Washington state. And that has so proven not to be true. I think we need to see it for what it is, and we need to stand up for the rights of, and remember, it's not just our rights. Like, it's so important how we articulate this, because it's true. It's the free speech rights of everyone. I want my opponent to be able to advocate for things I don't believe in, because I also want to be able to advocate for that. And that's how you get to a reasoned decision that makes sense. It's what's made our democracy thrive. And I think it's what's helped us to continue to coexist peacefully as a nation. If we lose that right, I'm not sure we will continue to have the right or the ability to continue as a nation that's peaceful. We're seeing what's happening there.
Right. And so you're pretty confident that these are not just isolated cases, that these are reflective of things that are happening that don't make it into the public eye. People who don't have the resources, who don't know that they should contact ADF, who don't know that they need to go to the media, that a lot of these cases, or are they more canary in coal mine type situations? Or should we right now say we're past the tipping point? Do you think that we're heading towards this, or do you think that we're already there?
We have hundreds of open cases right now, and almost all of them deal with the issue of whether you have the right to be able to speak freely or to live consistent with your convictions. We can't keep up. And then you add on top of that the COVID restrictions that we've seen and the restrictions on religious liberty there. And it is just a mounting tide that I believe we will overcome if we continue to litigate these cases in the courts, and frankly, continue to have conversations at our own dinner tables with our kids and at the end of our driveways with our neighbors about why it's so important to voice our views and to stand up for truth.
And without fear, and that's such an important aspect of it. I wonder, you mentioned the COVID cases, and I think there's there's mounting suspicion on the right, and probably with some people in the center, that Democratic lawmakers are using COVID restrictions as a way to, almost that they're enjoying it. They're enjoying the way that they've learned they can use their power. Has that been something that you've noticed as you're reviewing these cases and working on them?
Yes, I would say, initially in March, when we were dealing with calls, we were inundated with calls from churches and religious organizations and individuals about what to do. And as we would work with predominantly local government officials, some state AG offices and governors, we would say, these are the constitutional rights. These are the rules you need to live by. And some officials just acted naively. They weren't aware of their rights. And those officials would quickly change their orders to make them apply equally, fairly, and consistently with the Constitution. But now that we're out of that initial era, those that continue to force these unequal restrictions on religious worship, I do think are doing it intentionally and overtly in defiance of the law. We have a case in Nevada, the Calvary Chapel case, where it's beyond ridiculous. The restrictions where casinos are open, Circus is doing shows, there's live performances, and yet churches can't meet, subject to very small restrictions of gatherings. That's completely unfair. And yet the Nevada governor is persistent that he will keep that order in place.
What do you think the motivation is behind that? Is it an anti-faith bias? What do you think is motivating these decisions? Is it like I said, is it anti-faith, or is it a power grab, a combination of both? Are they trying to hamper people's ability to organize in religious communities? Because as you explain it, it sounds so on its face unfair and illogical, and like something that's just so easily lost in court on their behalf. So why do you think they're doing it?
It's hard to say why they're doing it in terms of, I try not to ascribe motives to people, but I would say from the outside looking in, it appears to be both a power grab and an overt hostility to people of faith and religious communities. They're in the states where we're seeing it. There's no question that there is not a deep understanding of the importance of faith or religious communities by those government officials. And so I think that also creates a lack of empathy, a lack of understanding about what their legal obligations are. And frankly, they just don't care in many ways. The second piece, though, that I would raise is when many of these cases we've prevailed in, but when we haven't prevailed, predominantly the courts have relied on a case that's over 100 years old. So this idea that we can sit back and do nothing now and these decisions can come down against us and restrict our freedoms and that they won't impact us later is false. It's proven by the exact situation we're in. What we do now matters.
And the Christian community has been raising this issue around the country. I wonder, I know you guys work with other faith groups, absolutely. Have you had, other representatives from other faiths collaborating on some of these cases? Are they also concerned about these restrictions, people beyond the Christian community?
Absolutely. We've seen a number of Jewish communities which have been hit the hardest, and so we're working with those communities as well. We're working with like-minded organizations who have been involved in this fight and public interest groups that are working on them. We have to work together in these moments because, frankly, there are too many cases coming up, too many local orders that are defying the Constitution for one organization to do it alone. And that's why we're the Alliance Defending Freedom. And when we believe in an alliance, there's no one group that can solve these problems or litigate all these cases.
What's one of the most interesting coalitions, or one of the most interesting partnerships from people or groups on both sides of the spectrum that have come together for a common cause? I'm sure you've encountered that many, many times. We were talking earlier about how the ACLU used to collaborate with people very much on the opposite end of the spectrum. But is there one partnership that stands out to you?
I would say there are two partnerships that come to mind right away. The first is the partnership on fair play, ensuring that female athletes have the right to be able to win, not just to participate, but to win in their chosen athletic field. We have radical feminists that are coming alongside of conservatives. We have pro-life, pro-abortion that are coming together. We have women standing side by side in those. And that's been really encouraging to see. I think a second thing is in some of our free speech cases, we've been a part of launching the Philadelphia Statement, which is a statement that we are asking broad coalition to sign on to support the right of free speech for all people. And that happens in our cases as well, where we see a number of groups that aren't ideologically aligned come together. And certainly it's really common in our religious freedom cases to have people of all different faiths file in favor of religious freedom. That was true in Jack Phillips' case in Masterpiece Cake Shop, and is true in many others as well. Almost every case we have at the Supreme Court, you will see that happen.
You know, the female athletes question is such an important one. I wonder if you have an opinion on the legislation that was introduced by Senator Loeffler last week and co-sponsored by Senator Blackburn and Cotton and I forget exactly everyone. I think Langford and Mike Lee as well. That would uses Title IX. I think this is pretty smart. Uses Title IX as the basis to protect women's sports and says if you get federal funding, then you must comply with Title IX. And Title IX says sex. It doesn't say gender identity. Do you think that's a good piece of legislation and that it's within the scope of their constitutional duty?
I do think it's a good piece of legislation. I'm not sure that it will get passed in this moment, but as you know, those types of bills continue to need to come before the Senate, and hopefully eventually it picks up the momentum that it should. I think that it is a belt and suspenders approach in terms of Title IX already says that women should be protected. It says that they should have equal opportunities, and by reading in gender identity and letting biological men compete against women with all the physical advantages that they have, that in and of itself violates Title IX. And I'll just add, we haven't talked about the Department of Justice's position in these issues. And I think it highlights some of the distinctions between the two administrations. As you said, in the bathroom policy in the Obama-Biden administration, they came out strongly in favor of obliterating the distinctions between men and women. But the Trump administration, through the Department of Justice, has actually filed a notice and investigated these schools in Connecticut, for example, and said that they're violating federal law by discriminating against young women in this way.
And you're now in the position where you're having to make the argument for why women and men have different physical levels of ability in sports like track. It's just it's a ridiculous place to be in, and it's where we've come to. But what does the argument go? I mean, obviously people can do the research and they can. I mean, it's one of those things that's very instinctive, and we know as humans that men and women have different physical abilities. You do not know that necessarily if you are on the far left, and it's not what you're taught in college campuses. It's not what most people are taught on college campuses anymore. But what do you focus on when you make that argument?
Well, like you said, we focus on the biological differences. So, particularly on the athletic field, I know we should just know this intuitively, but I've got to tell you, I didn't really think about it deeply until I was working on the brief and helping to edit the briefs that were being filed in one case to look at the expert reports. And those experts are saying, look, it's not just about being bigger and stronger, so to speak. It is the size of your heart. It's the length of your bones. It's the size of your lungs. I mean, we are so different in terms of our physique that there's no hormones that can be taken, no surgeries that can be done that will ever make up for that difference. And so you can never give women a fair playing field if you're forcing them to compete against men who naturally have a biological advantage.
And the young women that you all are working with in that case, I imagine they're not people who ever wanted to be involved in this highly charged political issue. They're probably just girls who wanted to win and get scholarships. Is that correct?
Oh, it's so correct. Absolutely. In fact, Emily, I can't think of any case that we're litigating right now. I'm sure, there are hundreds, so I might be missing one, but I can't think of any clients that even I've represented here that have ever wanted that. They don't want the spotlight. They just want to live their life. They want to serve their communities. They want to operate their businesses. They want to be good neighbors. And they're thrust into the crosshairs of this political agenda with so much at stake. I mean, the Harris Funeral Homes case, which we haven't talked about, but came out last year, that's a perfect example of a family-owned business that is facing such losses because they were a test case picked out by the Obama administration and then the ACLU.
Mm-hmm. What was most disappointing about the Harris decision in terms of the logic behind it?
Well, we're arguing a case before the court in January, and I really don't want to make anybody mad that might be deciding that case. But
that's fair.
I don't think that it's a secret that We were deeply disappointed in Justice Gorsuch's decision and feel
That's
that
what I was
it's
getting at.
deeply flawed. It's
Yeah.
deeply flawed. It seems to be more of a literalist interpretation without any context, and I think is going to do great harm. We're already seeing it do great harm to women and girls, to individuals, and to way some of the progressive liberal courts are applying it below.
Can you talk about some of those examples and how we've already seen that decision be harmful?
Sure. Well, we've seen it, cited in the Title IX cases involving, decisions that have to do with the differences between men and women. We've seen it cited in an example of harassment and sexual harassment and how that might apply and really misused, including a plaintiff that argued the decision meant that if customers misgendered him, either intentionally or accidentally, the employer had a responsibility to correct the customer in their shop. If you think about just, again, the differences that exist that are natural, they're important. We think about the pronoun cases. At first I thought, okay, so what's the significance of being forced to use a pronoun that you object to? Like, is this something that is important? And as we look closer at it, there's no question. Because if the government can tell you what to say and not say, and to affirm a reality that you believe to be false, then it has unlimited power. And these aren't cases where someone's intentionally ostracizing or shaming. Like, they're looking for accommodations from these universities. They're saying, I won't use any pronouns at all. That's not good enough. Instead, you have to actively affirm something that you don't believe in.
Yeah, and I'm glad you bring that up, because it does seem like the attitude when you talk to a lot of people who might be on the center on this issue or on the left, it's like, what's the big deal? Why can't you just say it? What's the big issue here? But I'm glad you raised that point. And thinking about that Dear Colleague letter, and that I believe was issued in 2016. I think it was like May of 2016 by the Department of Education. Camille Paglia actually said that was the moment she knew that Hillary Clinton had lost the election, which I think is a really interesting point. And she was essentially saying that this is such a radical thing that it's so indicative of where the culture is heading, and it's, you're codifying it now from the government. I imagine the Biden administration would eagerly reinstate a letter like that from the Department of Education, that they would eagerly, whatever it looks like, whatever form it takes. The Equality Act would be difficult to pass, unless they have the Senate. And so I imagine that they would try to use the administrative state to sort of push through these things again. What would the consequences be of something like that? And why is it such, this is an obvious leading question, but why is it such an outrageous overuse of power to make such a big decision with just a simple letter?
Well, I mean, I think first of all, again, we've talked about the distinctions being equal but not interchangeable. And in the Dear Colleague letter that the Obama-Biden administration issued, it essentially threatened public schools with the loss of their funds if they didn't go along with this agenda, which was to ensure that boys and girls would be able not only to use the same restroom, but to undress in front of each other. And we actually had a case that involved that, where a young 17-year-old boy was in the boys' locker room and turned around while he's undressed, to see a young woman who was identifying as a man in her bra. And, and yet that student was so afraid he didn't even want to be identified in the lawsuit because of the bullying and intimidation and threats that he would get from those on the radical left. So think about those things. Or, we had a parent call and say, I got my daughter into an all-female dorm. Unfortunately, across the hall is a man who sometimes dresses as a man and other times as a woman. And they're sharing a shower room, an open shower. Those are things. And then again, we go to the athletic field and the women's shelters and all of those things. I mean, it brings real physical threats and potential violence even to women and girls. And how are we going to track those now? I mean, think about the programs that are set up for women right now and how we track violence and things like that. It opens up such a Pandora's box. And in the end, it treats women as second-class citizens. Men who decide to identify as women do not have a woman's experience. They just don't.
And I imagine as you're working on these cases and arguing these cases, it's such a difficult thing to do because you have to have the utmost sympathy for people on the other side of it who, and the Harris Funeral Home case is such a good example. Somebody who was part of this family business for years and was clearly struggling. And that has to present an interesting challenge on your end.
Well, I think I'd probably carve out that on the Harris Funeral Home side, I mean, the importance of that case was 6 years prior when Tom Ross hired the employee Stevens. There was a dress code that was in place, and Stevens agreed to that dress code and followed that dress code for 6 years. And so then to say, I'm returning to work and I'm going to dress as a woman as your funeral director and the front face of your funeral home, put him in quite a situation, including where there was only one restroom, and even an 80-year-old employee, a woman, was to share that restroom. So he had to struggle with that. And as I said, the law was on his side until the Supreme Court changed the law. But in terms of the struggle overall, I think we have great empathy for those that are struggling with gender confusion, gender dysphoria, especially the children. Sorry. When I think about it, and I think about my own kids, and just, someone that is struggling with that needs appropriate help. And to suggest immediately that appropriate help is to provide hormones or to provide surgical therapy when there is not studies that suggest that that's going to help. In fact, the studies are starting to show it can harm them. It's malpractice, and I think it violates our obligation to love our neighbor. So we have empathy and we want to help, but the left is not helping. They're making it worse to pursue their own ideological agenda, and it hurts kids and it hurts families.
Yeah, that's so true. My final question for you is maybe on a lighter note, which is it's a very simple question. What is it like to argue before the Supreme Court? You probably get that question a lot, but what is, preparing for it? Are you also preparing to sort of interact with the personalities that the justices have? What is the process like for you?
It's such an amazing privilege, and I'm getting ready to argue another case, a case involving a student whose speech was shut down. He was silenced not once but twice on his campus, and that case will likely be heard in January or February. And so I'll tell you right now, I've got a dozen binders in my office. I've got to master you master hundreds of cases. For me, it's a really intense process. Others don't have to approach it that much, but as my dad's always said, I might not be the smartest in the room, but I do intend to be the hardest worker. So that's how I compensate. But it is, as I said, it's a privilege. You do think about the personalities. You think about, we look at each justice's opinions and maybe where they are on particular issues so that we can anticipate concerns they would have. Because you're there not to argue what you want to argue, but to try to address the concerns that they have as they are sort of arguing with one another. You just get to observe and participate once in a while during the oral argument.
That's so interesting. And I said the last question, I came up with one more question as you were speaking. The left is very convinced right now that if Amy Coney Barrett is confirmed, some of these religious liberty cases and a lot of cases in general will start to go against them more and more and more. And they're worried that this is just going to be a conservative monopoly on Supreme Court decisions for years and years to come. Now, on your end, are you optimistic that the makeup of the court, if Amy Coney Barrett is confirmed, will be really helpful to the cause of religious liberty? Should the left be concerned about Amy Coney Barrett?
I'm optimistic that we look at what someone has written and what they have said to predict their future behavior. I think what the left is saying that Amy Coney Barrett has written and said is patently false. She's not said anything about what her positions are going to be on particular cases, or even in many respects, particular issues that would be the hot button issues. We don't know. So I can't guarantee that. Of course, I want to be hopeful. But I would say, again, it goes back to that, the people understanding what is an originalist. And an originalist is one that approaches the law, hopefully with integrity, with a sense of realizing there are limits to their authority, and that it's the legislature's job to pass laws It's not the job of the judiciary. She's also expressed again and again a commitment to stare decisis in appropriate cases, which means a commitment to say, okay, if the Supreme Court has decided a case previously, before we're going to reverse that, we're going to look at it very closely. We're going to look at how it's played out in the law. And I believe she'll honor that. There's even Noah Feldman from Harvard, who clerked with her at the Supreme Court, who's a liberal, says, you know, she's a person of integrity. She's a person that has a brilliant mind, and there's no reason to disqualify her other than the left is trying to say it's because of her faith. And that in and of itself is bigotry and unconstitutional.
Well, ACB aside, I mean, do you think there is actually a real threat to Roe v. Wade? Do you think that there would be a situation where the left has predicted some like sort of chipping away at that over a series of cases in coming years? Do you think that's a reality or a possibility, whether or not it's Amy Coney Barrett or somebody else?
I wish I was as sure as the left is about these things.
Right.
You know, we've been hearing it for decades. It's a decision that was wrongly decided. Even Justice Ginsburg has expressed concerns about the Roe decision. So, you know, people on the left and the right realize that it has a lot of false premises in it. But whatever position she takes, I'm hopeful on Roe. I'm hopeful that she will protect the rights of all Americans. And as I said, even Professor Feldman, I think it was, said, or it might have been another Notre Dame professor that said, she's not even ideological. She knows what her role is on the bench and will follow that role, which means not engaging in policymaking.
Well, as our listeners can probably tell, I could keep going for a much longer period of time. We appreciate so much you joining us today. Kristen Waggoner. Is the website adf.org?
adflegal.org.
adflegal.org. Kristen Waggoner, General Counsel of Alliance Defending Freedom. Check out their website. Go to them if you have anything like this, as we've discussed over the past hour or so, happening in your life, or if you know anybody who has something like this happening to them. ADF is there to help. Thank you so much for your time.
Thank you.
All right. We'll be back soon with more. Until then, be lovers of freedom and anxious for the fray.